So hi, my name is Cristin Lowe. We're going to dive right in and get started with the beginning forms that you need to start your divorce process. So on my website, which is CristinLoweLaw.com, we have quick links, and on the far right side we're going to go to commonly used forms. So just a hint, all of the family law forms start with FL standing for family law, and we are going to start at the very beginning with what's called a petition, or a request for a divorce. And we're going to click right on the link, which is petition FL-100. Now this is a brand new updated form for 2015, and we are going to start right now. And at the top, this is going to be identical for every single form, or I should say almost every single form that you fill out, so get used to this. The first thing you're going to put up at top is your name, and you're going to use your full legal name, no nicknames. You don't have to use a middle name, but you do want to use a full name. So in this case, we're going to keep it simple. We're going to have the petitioner's name as John Smith. And John lives at 124 Rose Street in San Ramon. And you don't actually have to use your own home address, because a lot of people are in the transition and they're moving and that sort of thing. So if you would rather use a P.O. box, or you would rather use your parents' address or your best friend's address, basically we need an address that's going to stay put for the duration of your divorce. And let's have San Ramon, California, and the zip code 94582. The next thing you're going to fill out is a phone number. Again, you can use your cell phone number, you can use your home number, you can use a work number. You basically need to use a number that the court can reach you at. So we're going to use the number, and we're going to pretend it's John's cell phone number, so not a 925 number, but a 415 number for San Francisco County. So 415. Let's do 442-5577. And if you don't have a fax number, you don't have to fill it in. And if you don't have an email address, or you don't want to disclose your email address, you don't have to do it. Neither one of those is mandatory. The next part though, attorney for, well, you're doing this on your own. So you're something called in pro per. The fancy schmancy word is in propria persona. So either one will work, but we're gonna put in pro per, which basically lets the court know that you're self-represented. You don't actually have an attorney except for yourself. Okay, so we are now in the Court of California, County of, and because John lives in San Ramon, he is filing in Contra Costa County. And Contra Costa County right now only has one family law division, and that's located in Martinez. So all of your filings, whether you live in Danville or Alamo or Richmond, everything's going to be going to Martinez. And the street address there is 751 Pine Street. And the mailing address is a little bit different. It's P.O. Box 911. And as I said before, we're only in Martinez. So the city is Martinez. And of course the state is California. And the zip code is 94553. It is optional if you want to name the branch name, but just for reference, and when you go to the courthouse itself, the name of the branch is the Peter L. for the middle initial, Spinetta, S-P-I-N-E-T-T-A, Family Law Center. And then we're going to have the petitioner's name again as John Smith, and the respondent's name as, in this case, Jane Smith. And I'm going to have you check the box petition for dissolution. And the petition for dissolution, they have finally updated the form in 2015. I love this. It says divorce now, so we don't have to use the fancy term for it. Simple dissolution. And in this case, we're going to say it's of a marriage. So the next thing we're going to screen all the way down, so you're not going to see this part again, but I want you to see this right now. Specifically to Contra Costa County, you need to know that the clerk window hours are, and this is subject to change, but right now, as of 2015, the courtroom hours are 8 a.m. to 1 p.m. So when you want to go to the courthouse to file your documents, you need to be aware that the courthouse opens at 8 and the window closes at 1 p.m. For more information, we're going to direct you to a link that gives you a brief tour of the courthouse and where to park, and give you a little bit more information about that. All right, so we have now scrolled down. We're on number 1, legal relationship. And in this case, because it's a divorce, it is we are married. So you're going to check the box 1A. Now in California, we have what's called a no-fault state. So it doesn't matter the reason why you're getting a divorce. So if you're worried about being the petitioner or the respondent, I don't want you to worry. They are names, they are titles, they don't mean anything other than who you're referred to and who initiates and who responds. There's not a whole lot of legal advantage or disadvantage to being one or the other. There may be reasons that you have personally in your life for wanting to be one or the other, but that's not important for purposes of the law. So I want you to understand that you're not prejudiced or harmed in any way because you're starting the divorce, and you're not prejudiced or harmed in any way just because you're responding to the divorce. But what you do need to meet is a residency requirement, and this is only one of you. But basically, in order to file for a divorce in California, one of you has to be a resident of the state for at least 6 months prior to filing, and whatever county you're living in, you have to be a resident for 3 months. We don't need you both, we only need one of you. So for example, in this case, if John has been living in San Ramon for at least 3 months, and in California total for 6 months, he can comply with the residency requirement. So he can check the box to a petitioner. So he's going to be the resident of California. Let's say that Jane actually lives in Alameda County. Could she qualify for filing divorce in Alameda County? Absolutely. But because John's filing and he wants to file in Contra Costa County, he can start it off by saying he's the resident. Number 3, we're going to skip down to number 3. We need statistical facts. So the first thing is date of marriage. If you don't know, go look at your marriage certificate. And yes, you're not unusual if you don't know or don't remember if it's been a while. So in this case, we're going to pretend that John's date of marriage was February 24th, 2004. And we're just going to put that down there. You can put just the numbers, or you can put the whole kit and caboodle. It's up to you. Doesn't matter. And then we have a date of separation. Well, what does the date of separation actually mean? It is one of those complicated legal concepts, but basically it's the date that you or your spouse believes that your marriage was over. It has important legal meaning, so I don't want you to go just pick a date 5 years ago just because you feel like it. And even though you might think that your marriage has been over forever, you want to really think about when you truly believe that the marriage broke down, because there are legal consequences to it. In a nutshell, anything acquired or earned or incurred after that date of separation is your responsibility or your own property, and anything before the date of separation, meaning during marriage, is considered community property or presumed to be 50-50. So for example, if I went out and charged $10,000 on a credit card before the date of separation, it would be presumed to be 50% mine and 50% my spouse's. But if I charged it after that date of separation, it's going to be my financial responsibility to pay for it. So it's very important that you consider what that date of separation is. The other reason for date of separation is it also determines the length of your marriage. And we have kind of 2 types of marriage in California. We have a short-term marriage, which is under 10 years, and we have a long-term marriage, which is anything above 10 years. And those are presumptions, and there are ways to argue one way or another, but those are kind of the general guidelines or the rules that you want to abide by. And kind of the things around spousal support change once you hit a long-term marriage. So if you're somewhere between that 9 and 11-year mark, you might want to consider talking to an attorney just so you understand more concretely and more in depth what a long-term versus a short-term marriage might mean for you. In this case, we're going to have John have a long-term marriage, and we're going to have the date of separation to be January 16th, 2015. And again, you don't have to fill out the full words if you want. You can use just the numbers. And now comes the math part. So we need to calculate what exactly the length of marriage is. So in this case, he's got a 10-year marriage, and he almost made it to 11 years, but he didn't quite make it there. So we have 10 months, because the 16th is before the 24th. So a 10-year and 10-month marriage. All right, going down to number 4, we have minor children. So what are minor children for purposes of a divorce? So it is a child who is biologically yours and your spouse's, or it's a child that one of you has adopted during the marriage, or both of you have adopted during the marriage. So they are either biologically yours or legally yours through adoption. So in this case, there is going to be a minor child, so we're going to check the box 4B, and we're going to list the child's name. In this case, they have one child, and his name is Ryan Smith. And Ryan's birth date, we are going to have it as April 20th, 2006. So that's going to make him 9 years old this April. So we'll put 8 now because we're not actually in April. And he is a male. Okay. And just so you know, what 4C means is there's another form you have to fill out. And that's FL-100, and we speak about that in another video, and we'll get to that later. But just so you understand what this form means, that's what that really long word says. If, for example, Ryan was born prior to the party's marriage, he's not legally presumed to be the child of the marriage yet. And by checking box D, that's when he or she could become a child of the marriage. All right, so that takes us past page 1. We're going to scroll down to page 2. That is one of the big differences between the form, how it was for many, many years, and how the new update in 2015 is, which is, that is now 3 pages. And it's not more complicated. I actually think it's a lot more user-friendly, and it breaks things up a lot better. So I'm really happy with the changes. Legal grounds, number 5, the reason why you're asking for a divorce. So as I referenced earlier, divorce in California, it's a no-fault state. We don't really have a basis. It's not a fault. We don't care so much about why the marriage is breaking down or whose fault it is. So what's important in your case is, for most people, it's irreconcilable differences. So in this case, we're going to check the box divorce, 5A, and we're going to put irreconcilable differences. The other basis for a divorce would be permanent legal incapacity to make decisions, and that's a really, really narrow category, and very few people qualify for it. Before, it used to be incurable insanity, and I would get questions, well, I think my spouse is insane, can I just check that box? And the answer is no. We're really talking about a permanent mental illness that makes them unable to make decisions, or something like Alzheimer's disease, where they're just not able to ever come back from that and kind of participate in the marriage like they used to. I get a lot of questions on what's the difference between divorce and legal separation, and that's one of your choices here. And I like to think of it as legal separation is identical to a divorce, except it stops one step before a divorce. So just like a divorce, legal separation deals with the kids. So we deal with child custody, we deal with child visitation and support. We deal with the issue of spousal support or alimony. We deal with property division, debt allocation. We deal with attorney fees, reimbursement claims, every issue that you would in a divorce, except that a legal separation stops there. Divorce takes you one step further and terminates your marital status, meaning that you're a single person again. So unlike a legal separation where you can't remarry, a divorce makes you single again, so you are legally able to remarry. All right, so we are going to go down now to number 6, child custody and visitation, which was one of those issues that cover dissolution of domestic partnership, legal separation, and divorce, anytime there's a child of the relationship or of adoption. All right, so the first thing we have to answer is the question of legal custody. So what is legal custody? Legal custody deals with the big ticket items. Who gets to make the decisions about the children's lives? Medical decisions, where do they go to school, childcare, extracurricular activities, the day-to-day kind of parenting decisions that you would think about making. And in this case, John is going to ask for joint legal custody, meaning he would like to share the decision-making with Jane. So we're going to check the box 6A, and under joint. Physical custody, we're also going to check the box joint. And physical custody is essentially, where does the child live? In this case, where does Ryan live? Physical custody, saying joint, doesn't automatically mean it's a 50-50 or everything's identical, or we spend 1 week with mom, 1 week with dad. What it means is that the child, in this case Ryan, spends substantial amounts of time with both parents. That doesn't mean equal, it means significant. So we're not talking 1 weekend a month or 1 month a year. We're talking something more than that. Okay, so this is another new section. Number 7 is child support. And you don't actually have to fill anything out here, but it is a more clear advisement. So anytime you file for divorce and there is an issue of custody, meaning there's a child of the marriage, child support automatically becomes an issue. So whether or not you want child support from your spouse, or whether or not you want to pay child support to your spouse, that issue is automatically alive. And we say that you can't terminate it, you can't waive it, you can't get rid of it. You can reserve on it, meaning it's going to be 0, but you can't get rid of it because that's your child's money. And child support lasts until the child is 18 and a graduate of high school. So if we go back to our example with Ryan, his birthday is in April, and let's say he turns 18 his senior year in April. Child support's going to go until he graduates in May or June, or whenever it is that he graduates that year. A lot of questions I get have to be around wage assignments or earning assignment order, which you can see in 7B. Basically, under the law, a wage assignment or an earnings assignment order has to issue. It doesn't matter, it's not a statement that you're bad or that you're good or that you're entitled to it. That is a legal process of doing child support. Now, the two of you can agree not to do the wage assignment or the earnings assignment order, but it's something you should expect and be prepared to have as part of your case anytime there's child support. Number 8, spousal support. The first thing we're going to check is 8A. Does John want spousal support from Jane? And let's say he does. So we're going to check the box 8A. And spousal support or domestic partner support payable to, who in this case, he's saying he wants spousal support. So he would check the box petitioner. And I want you guys to be very careful at this, because a lot of times it's easy to check the wrong boxes. So you want to ask yourself, do I want to pay spousal support or do I want spousal support? That's a better way of framing 8A. So if you want spousal support, you need to check the box petitioner respondent, depending on who you are. And if you want to pay spousal support, then you want to check the other box. All right, so the next one is B, terminate or end the court's ability to award spousal support. It's the same thing. It's one of those easy things to mix up. So you think about it. Do I want to pay spousal support to my spouse? Yes or no? If I don't, then I want to check the box for the other party. So in this case, John doesn't want to pay spousal support to Jane. So he's going to check the box B, 8B, and end the court's ability to award spousal support to, not him, because that would be the mistake. We want to check the box respondent, meaning her. A lot of people get confused by checking these boxes and then they wonder, well, why do I have to pay spousal support now? I said I didn't want to pay spousal support here. And understand the petition, just think of it like the regular word petition. It's a request. It's asking. It's not a guarantee. It's not a court order. But it does set forth your preferences and what it is that you want or don't want. Reservation, that's another concept I get a lot. So reservation means we're not going to decide now. We're not going to decide today, but I want to keep the door unlocked. So it's shut because we're not going to determine it right now. But at a later time, I might want to open that door and step through it and ask for spousal support. All right, so we're going to go on to number 9, which is separate property. So separate property, I talked about a little bit at the beginning of the form, but basically the definition of separate property is anything acquired before marriage or after separation. Other property that can be considered separate property would be gifts and inheritances. Those are kind of your big categories of what is separate property. So in this case, we're going to say that John doesn't know of any separate property items. He's been married a while. He got married, let's say, straight out of college, didn't have anything beforehand, and neither did Jane. If there were separate property items, let's say an inheritance, or there was a big ticket gift from his parents to him, then he might want to list it there. So you would list down what it would be and confirm too. Okay, we're going to scroll down to page 3 now. Almost done. We're 2/3 of the way done here. And community property and quasi-community property. Very rarely do you deal with quasi-community property. If you had property and you used to live outside of the state of California, that's when you might want to talk to an attorney, because that's when quasi-community property applies. But if you've been living in California and all of your properties here in California, we're only dealing with community property. So for most of you, we're only talking about community property. So people get confused about community property because I get a lot of questions. Well, I don't have anything, so there's nothing to divide. And in probably about 99.9% of situations, that's not true. So just because you have or don't have a house doesn't mean you don't have community property. Okay? Community property means everything you own and everything you owe that was acquired or incurred during marriage. So we are talking about things like property. We're also talking about things like vehicles. We're talking about things like bank accounts, the pots and the pans, the retirement accounts, timeshares. I've seen everything from motorcycles to competition bikes, debts like credit card debts, back taxes. Anything that you own or owe is going to be community property if it was acquired during your marriage. So in this case, we're going to check 10B, and we're going to check the box as follows. And we're going to list that. So this is kind of optional. A lot of attorneys will say, well, just put to be determined at a later date, or see attached list, or will be provided later. And I'm not a big fan of that because I like to list it out, and I don't need you to list every pot and pan that you own or all the sheets and the towels and that sort of thing. But what I like to do is I like to give a list, a general list of what is out there. It makes it clearer for the court, it makes it clearer for your spouse, it makes it clearer for you. It gets you starting to think along the right lines. So in this case, we're going to say that John owns his house. So the real property located at 124 Rose Street. And the other reason why I like this is because in a default case, meaning your other spouse isn't going to participate, you are limited to what you put in the petition. So more detail is better than less detail. And we're going to finish that up with San Ramon, California. And I like to use the word "and its encumbrance," but really what I'm saying is "and the debt or the mortgage," because very few people own their house outright. Most of them have some kind of mortgage. ENCUMBRANCE. And then I put a semicolon and I start listing the other things. I usually put miscellaneous, household furniture, furnishings, and appliances. And I will put the vehicles. In semicolon, I usually put bank accounts. Semicolon, let's say there are life insurance policies. Semicolon, and we have retirement accounts. And let's say there's credit card debt as well. Okay, so this didn't take me a whole lot of time to write out, but it gives me a better idea of what's out there rather than "to be determined" or "will be listed at a later date." It just gives a little bit more clarification to everyone. All right, we're going to keep going down to number 11, which is other requests. And 11A, attorney fees and costs payable by who? And it goes back to that spousal support issue. So be careful when you read this and check the right box. So if you want attorney fees paid, and let's say John wants, because he wanted spousal support, he wants Jane to also pay attorney fees. So attorney fees and costs payable by who? By Jane, who's the respondent. So attorney fees in California are awarded under two bases. We have Family Code Section 2030, which is a need-based award, essentially. We look at income or assets available to pay attorney fees. So we're looking at not just John doesn't work and Jane does, but we're also looking at who has available money. So sources from retirement accounts or equity in houses or separate property or inheritances. All of that can be considered in attorney fees. So it's a fairly complicated way of determining whether or not somebody needs attorney fees. And I know that's a raw subject, and I know nobody is really happy about paying for their spouse's attorney fees, but you should be aware that if you are in a financially superior position than your spouse, you should be prepared to potentially pay attorney fees for your spouse, whether or not you have an attorney yourself. The other grounds for an attorney fee award would be under Family Code Section 271, which I call like a fine. It's a sanction. It's for bad behavior. It's for frustrating settlement. It's for not showing up to court on time. It's for doing things in bad faith. It's for not really helping the case out very well. All right, and 11B, if you had changed your name during the marriage and you want to restore your maiden name or hyphenate or change it some way, you can fill it out there. What you want to do, and this is one of the few things where you get away with it, is that you can change your mind at any time. So if you don't know whether or not you want to restore your maiden name or hyphenate, you can leave that blank. If you know for sure now, go ahead and fill it out. All right, so number 12 is very important. You don't have to actually fill anything out, but you do need to read it, which is I have read the restraining orders on the back of the summons, and I understand that they apply to me when this petition is filed. Well, we're going to get into that in a more in-depth discussion when we go over Form FL-110, but for now what you have to understand is by signing this petition, you acknowledge that you are under the ATROs, or the Automatic Temporary Restraining Orders. So the last thing to do is signature of petitioner. So you're going to type your name. So in this case we have John Smith. And if you're doing this on the computer and you plan on printing it out right away, you can always drop the date in. If not, always remember the date's above your printed name. It's in a very, very bad spot once it's printed out of the computer. Everyone misses it, so don't worry about it, but you must date your documents. And then you will need to sign it. and the date you sign it is the date that you're ready to get it filed. So this wraps up Form FL-100. Our next form that we're going to be covering is the summons, which is Form FL-110. So congratulations, you've just finished your first form, the petition FL-100, and this is the first step, like I said, as to starting your divorce. So the next form we're going to be covering is the summons, which is Form FL-110. So if you have any other questions or didn't understand a part of the video, please call us. We'd love to hear from you. We'd love to help you out. Our phone number is 925-215-1388, or you can reach me by email at Cristin@CristinLowelaw.com.